the Colorado Oil and Gas Conservation Commission rulemaking on mission change. This morning, we initiated deliberations around the 600 series. I think that's still where we are at this point. I didn't really get a chance, but would look to Director Murphy. Do you have some perspective of next steps? I know we have provided direction, which is our general process. As we identify big issues, we provide direction. Do we need to further direct? What are your thoughts at this point, Director Murphy?
Chair, I'm going to talk fairly extemporaneously. One is we've heard a lot, I think, from parties, from staff, from me, about the enormous endurance race that we're all in. And so I've taken a crack at looking at maybe a revised hearing schedule for 8, 9, and 12 to give us all a little bit more space to work through some of those issues. So that's something I would like to talk about this afternoon with you and see if it is appealing, reasonable, etc. 2, I have data pulled together on the question from Commissioner Gonzalez about proximity of proposed and approved 2As kind of over time. I think we were able to pull data from 2013. And
Right.
Then the third piece is kind of just going back and trying to recap where I think that we are at. I mean, I think staff could take a cut at revising 604 based on the tenor of the conversation. But if commissioners want to continue to kind of work on the issues, you know, it's
okay.
Yeah.
Thank you for that. Before we turn to 8, 9, and 12, I did note that Hearings Officer Larson wanted me to remind folks a couple of just housekeeping matters. We understand that there's been some power outages across the state today, and we want folks to just be advised that all of our hearings are broadcast via our YouTube channel, which you can get to by going to the COGCC website. They also are recorded, and you too can go and re-listen to the debate that we had over and over and over again to your heart's content by going to our YouTube channel for those nights in which you're not able to sleep, perhaps. And then the last sort of piece, and I might have Attorney General Kyle Davenport speak to this, and I'm catching Attorney General Davenport cold here, but several commissioners continue to receive emails, some of which are from parties, and they are substantive in nature. And I'm just reminding commissioners that our policy on that is to delete and not read said emails. We have a case management order that determines how folks provide written perspective and feedback, and we're following that. AAG Davenport, do you have anything to add on that? I didn't get a chance to catch you in the hall about that, but just wanted to remind folks that that's our policy there.
Mr. Chair, I don't have much to add. The only thing that I'll do is reiterate what I said yesterday, and that's if a party would like to speak to an individual commissioner, that we ask that they send that request, email that request with a general description of what they'd like to talk about, and not to have substantive comments or documents attached to that email. And then each individual commissioner who is under no obligation to actually have that conversation can make their choice on whether or not they'd like to talk.
Great, thank you for that reminder, Attorney General Davenport. That's our process issues. Segueing on that, but before we dive back into 600 series substance, Director Murphy, do you want to shed light on your ideas about 8, 9, and 12 and the endurance race that we're in?
For the 4 billionth time of this hearing, I've tried to talk while my mute was on and shared my screen and muddled it all up. But I think from staff's perspective, at least, that's the only one I can really represent. Having a little space to work through some of these complicated issues, digest what we've already done, seem to make sense with a slightly revised hearing schedule for 8, 9, and 12. I know the parties are working incredibly hard in the midst of this 3-week hearing to prep on these other 3 series as well. So what I have in the first bullet point is the current schedule for the 800, 900, and 1200 rulemaking, including the 2 party deadlines, one of which is on Monday. And then to flag that we have kind of another 2-week chunk hearing scheduled. And you'll have to bear with me, at least, as we're learning how to work with a full-time commission as we go. And it seemed like 3 straight weeks made a lot of sense because we're just going to power through. And in hindsight, having a little space between those series to switch gears, to absorb, and to also respond wouldn't have been the worst plan on the front end, but now we can do it with 8, 9, and 12 possibly. And so the second bullet point flags what I would suggest you all consider for 8, 9, and 12. I think that, the 800 series, leaving it kind of on track makes some sense. It's a very technical, very focused rulemaking. The 1200 series, taking that up over the course of kind of the last few days of September and maybe into early October makes a lot of sense. To me, taking a respite to gear up for 1200, work through the 1200 series with our partners at CPW and the parties, and then take another respite and jump back into 900 series. For the kind of 10,000-foot viewpoint, we were gearing towards trying to complete having all the rules adopted by October 10th, which would afford a December 1st effective date. The proposed schedule does not comply with that clearly. It would comply as built today with a January 1st effective date. So that's one of the bigger pieces for you all to think about as you're looking at this. It affords just a little bit more time to work through some pretty important issues, I think. So this is my pitch. I'm probably not the best salesperson for it, except that all of us are tired. And maybe that's the most compelling piece.
Thank you, Director Murphy. I'll try to sell it for you. I think it is sensible and logical. I think 1 month's delay in turning on the new regulatory regime is absolutely worth the effort to make sure that we get it right. I don't know that any of us could have predicted the sort of exhaustion or the amount of workload that is involved with 3 straight weeks of hearings. Also, I need to commend staff. This commission has undertaken a process of deliberating and providing direction back to staff, which is not what you maybe contemplated was going to happen, and which increases staff's workload. I think the process is a very good process to end up at the right spot, but it does add to staff's workload. And so doing 1 week on, 1 week off, or doing the schedule as you have suggested, I think makes all the sense in the world. So I am a, for sure, heck yes vote on that. Other commissioners with thoughts around this? I see Gonzalez has a thumbs up, as does Commissioner Nanjapa, McGowan, and Messner. So the new rulemaking schedule is hereby adopted with 5 thumbs up.
Thank you, commissioners and chair. We'll get hearing officer Thomas working on a revised case management order to give the parties and public commenters a little bit more breathing room.
Director Murphy, will that also involve some more breathing room for responses and testimony? Is that accurate?
It does. We've kind of trifurcated the responses in this proposed schedule so that parties are filing 800 series as previously scheduled, but responses and testimony for 1200 series would be delayed 10-ish days, and then responses and testimony for 900 series would be delayed to October 9th, which I think will give parties a little bit more time, but also hopefully getting that information to the commissioners enough in advance to be able to peruse it thoroughly.
I think I saw a collective sigh of relief from all of our stakeholders that just happened, and I think this is the appropriate direction. I think this also is recognition of one of our core tenets, which is nimbleness. So thank you and staff for thinking about and coming up with a new alternate schedule that is best for Colorado. So thank you. With that, do you want to provide us with a little bit of the data that Commissioner Gonzalez in particular was looking forward to, and I think all of us were looking to?
Yep. So, okay, good. On screen, this is data that staff actually pulled a couple of weeks ago, trying to think through how it fit in and whether it would be helpful in the context of our 800 series. So it's the 2As submitted over time. And so you'll note the date that we pulled it together was August 26th. So it's not totally current, but it's pretty darn current. And the rows under the years summarize the year a 2A was submitted in proximity, and its proximity to the closest building unit. So this, I think, gives a pretty good spectrum of what it has looked like over the course of the last 7 years. And it's a good picture of what obviously operators have sought, and also where proximity is. I think it could be a good guide for what we will be facing in the coming years. So I mean, I don't want to, I'm not very prepared to like give some high gloss or overarching comments around this slide. And I also don't want to read to you row by row, column by column, because that will, I mean, make us all fall asleep instantly. But I do think that, you know, it's interesting to note, for the most part, kind of 2016 forward, very, very few 2As in close within 500 feet, right? That's been an important number that we've talked about. In terms of the 500 to 1,000, there has been a drop off, but also those are quite a few pads in that region. When you look at 1,000 to 1,500, again, somewhat significant numbers. And then also the 3,000 to 5,200, that's the biggest chunk, which is good news, right? But there's certainly a scattering of pads kind of throughout all of these distances. And this is my own inference, but if we think about the DJ Basin, and these rules obviously apply statewide and will have different impacts in a variety of places, but so much of the conversation on the Front Range has been a dual conversation of urbanization and increasing oil and gas development. And so I would suggest that there is a lot of urbanization on the Front Range, which is probably the most obvious statement of the day. But I think that that also consequently means that proximity will continue to be an issue between oil and gas and homes or building units.
Thank you, Director Murphy, for staff's quick development of this information. I think this is informative. Do commissioners have questions relevant to the information on the slide before us? Commissioner Gonzalez.
Yeah, just some quick math to bottom line what 2020 looked like, and it was a 30.25% almost. In this year alone, that would have been within the 2,000 feet, and I imagine with those operators, depending on how much analysis and alternative location they submitted under the director's criteria, that 30% would be likely coming before us for variance. And those numbers get bigger as you go back in time, reflective of the director's criteria and some of the limitations put in and around the timing of SB 181 passing. So not a question, but just wanted to bottom line that data.
Thank you for running the math. It's never been a high point of my intellect, so appreciate that. Other questions or comments from commissioners? All right, Ms. Murphy, seeing none, I mean, I think we've provided sufficient feedback. Oh, good, you pulled up that slide. I still think perhaps we need to give a little additional more feedback on the just kind of general direction on soft versus hard, or the variance or the exception. You know, I'll beat the same dead horse. I'm still of the perspective that, from my perspective, I would like staff to develop an exception where the receptor units, including tenants, have agreed, then that can come to us in the form of an OGDP with that exception built in. And I'm still of the perspective that I like the language, that sort of the general language that staff built around the proposed setback, that there can be a request to commission at the 510 hearing for a location that is within the setback, but that the operator bears the burden and the commission must make a finding that the alternative location continues to be sufficiently protected through COAs, through BMPs, through topography, through whatever that site-specific analysis is. And I personally don't need it to be more detailed out in drafting form. I kind of would like to try this on for size and have commission look at the 30% and you know, where operators are asking for a waiver and see how we do. But that's just one commissioner. I'll stop rambling and I'll look to others for thoughts and perspectives to us as a whole and to staff. Commissioner Messner.
Thank you, Mr. Chair. So to put a little more specificity on that, the comments that Chairman Robbins made, I do think that the consent piece and the exception needs to be informed consent. So they need to be informed of the potential impacts or understand what they're consenting to, and that they do understand the that. And so I think that's an important piece of that. And I'm okay with, and I do think that that exception process just goes into, you know, that becomes a meeting of the location standards and would go through a standard OGDP process. I do think the waiver process for the 2,000-foot setback outside of the exception, you know, I would agree, you know, can happen. I think it can happen through the 510 hearing process. I do think that, you know, a finding and then conditions of approval proving how the application is going to meet or exceed the protective standards of the original setback, as well as the mission of protecting public health, safety, welfare, the environment, and wildlife resources. And so I do think that's important, but I do think there's a process there that can be developed for that. And that so then the original setback would be 2,000 feet. I do think from a school standpoint that the setback is 2,000 feet to the property line of both the working pad surface as well as the school property boundary. And that a school board does not waive that, does not have the ability to waive that. While I appreciate the concept of not allowing any waiver for schools, and I understand the intent of that, I do think that there's these situations that I'm anticipating where, you know, when you're talking about 25, 30 feet difference between 2,000-foot setback, which could be a significantly better site and less impactful than something that would be 2,025 feet away. I'm just trying to figure out, I mean, I do think that it's important to be able to have that. And perhaps that goes through a variance process. I don't know. But, you know, I'm okay with if folks are set on not having any waiver abilities from school boundaries. I can go with that. I also think there are scenarios where in extraordinary circumstances, waivers could be granted if there actually is, you know, a more protective, less impactful siting situation. I think that highlights the questions that are in the slide, at least from my standpoint. Oh, the measured piece, how to measure. Where I'm coming from is the measurement is working pad surface boundary to building edge, if we're going to go with a 2,000 foot setback. So.
Commissioner or Director Murphy.
Thank you. I don't, if we want to kind of continue on and kind of commissioner by commissioner talk about these pieces, that's wonderful. I do want to talk more about the school measurement at some point, because we've had a lot of conversations about the school property line, and we spent a lot of time working on that in 2018 and developed the school facility definition with a lot of those pieces in mind. So I don't know how best to bring that back, or if you just want me to like plow ahead and jump into it now.
Jump.
Okay, so the present Rule 604 language, and forgive me as I'm trying to pull it up myself, proposes to measure the school setback of 2,000 feet as proposed by staff from the school facility. And our definition of school facility means any discrete facility or area, whether indoor or outdoor, associated with a school that students commonly use as part of their curriculum or extracurricular activities. A school facility is either adjacent to or owned by the school or school governing body, and has a legal right to use the school facility at its discretion. And it also includes future school facilities. I say all of those things to say that in 2018, we had a lot of conversation about the school property boundary, and schools end up owning a lot of property that isn't used by students or faculty as often, fleet maintenance areas, et cetera. And so I wanted to make sure that what I want to say is I think we have done what you are asking, but if we start using the school property boundary, that is different from what staff has proposed. And so I just felt like I needed to put a really fine point on that question to make sure I don't screw up carrying out staff's directions.
Thank you for catching that flag. I, for one, was not attempting to second guess staff's work and the 2018 work. I assume that 2020 staff believes that that work remains positive and protective and is the right location. Otherwise, you wouldn't have used it. I probably just was bumping along the school property line because we were talking about other property lines. So I appreciate the nuanced answer there. And I, for one, do not have any second guessing of staff's definitional approach to school facility.
No, and neither do I. I mean, I was just trying to emphasize that it's inside and outside.
Yep, and we agree. And we think that's important, and it needs to be where students, faculty, people are congregating and using. And that was staff's intent, and worked really hard to come up with something that accomplished it without but anyway, sorry, I'm talking in circles now because I'm proud of that work.
And so you should be. Just looking at your slide, I would like it sort of encapsulate what we've discussed so that anybody that missed the earlier riveting testimony and debate and deliberation will see it now. So I think that yep, there you go. Great changes there. And then it's to 1 unit. Distance, I think there's consensus, it's 2,000. And then I think you've captured the variance exception waiver component based upon discussion so far, as well as the riparian is a good idea, but we want to take it up at a later date. The only other sort of point that I had made in my deliberations was the concept of bringing in at Rule 301F this state commitment to engage when asked by local government early on, and to serve as a referral agency. I don't know that that needs to be in this document, but if you could just make a note of it for the 300 series edits. I don't think I saw anybody that like said that's a dumb idea or we ought not be doing that. I think we all have sort of had consensus that collaborating early on with local governments is the new world reality and will help identify good things as well as potential hiccups early on. So I would flag that. Are there other thoughts, comments from commissioners to Director Murphy or to each other? Commissioner Gonzalez.
Yeah, thank you, Mr. Chair. I'd like to challenge the consensus that we have. I don't know that it's there. We have a majority, it sounds like, and I seem to be the dissenting minority in that regard for distances, but I want to make the record clear on that. I've beaten my dead horse sufficiently. I think all the commissioners and staff know where I stand on this matter. But when it comes down to it, just kind of as a bottom line, my view on setbacks is they should be pretty prohibitive. If you're going to be within a setback buffer, I think that buffer should mean something. If you're going to be within an alternative location analysis, I think you better have a darn good reason for why you're going to be putting a site within that ALA buffer, and that's a big hurdle. I think that with the protections that we have through the ALA process, the 400 series, and if we had meaningful setbacks, I think the protections would be there, and I think we would be really honoring our mission in such a method of doing it. When I think about variances and I think about setbacks, I think if you're going to get 30% just on 2020 alone, which has been a low year for permitting, and you look at that and you think 30% of those would be seeking variances or within that variance area, I don't think that rules are meant to be broken in terms of that kind of to that volume, to that extent. So I'm speaking my piece, and I'll leave it there to get back to staff, and we'll see where things come back to.
Commissioner Gonzalez, I very much appreciate your perspective and what you're bringing to the table, and I did not mean in any way to by using the word consensus, I completely misspoke. You're right, it is majority, and I appreciate your perspective. So thank you for clarifying that. And to all commissioners, this is my first rodeo as chair. If I misstate something, let me know. I'm a lawyer. I got a cold back. So one thing that. So I appreciate that, and Director Murphy, we can hear from other commissioners. But one sort of final piece to this for me, and this is not written anywhere within the rules, but I think that part of the 181 paradigm shift in regulating oil and gas at the Colorado Oil and Gas Commission is this notion that operators and Colorado ought to know that historically, oil and gas regulation at commission has been the operator goes and spends a great deal of time and money planning a proposed field or location. And then they come to the commission, or they would come to local government. The plans are already identified and they show how they meet the regulations. I believe that the setback signal that we are sending, as well as the 181 signal that we are sending, to operators into Colorado is that as an operator starts to think about developing an area, the operator should check in with commission and with local governments early on and before locations are fully identified. And that's what I think this is saying. And I think that's what this 2,000-foot setback is saying, is that in particular, where you're planning on being closer than that to people, you really need to know that that's more difficult and perhaps not doable. And the way to figure that out is the change in approach, wherein operators do not go spend a year or two developing a plan and then coming into commission after the fact and saying, here it is. Instead, it's more of a proactive upfront work. And that I think also plays out into all of the local governments that are involved in this, whether that's Weld County, Garfield County, Adams County, et cetera. So, you know, I don't know that notion or perspective, and maybe that's just singular to me, but that's, I think, an important aspect to what we're doing, where we're going, that maybe isn't found within the pages of the proposed new rules. So again, I'll get off my soapbox and allow others to speak, or Commissioner Nanjapa.
Thank you, Mr. Chair. I definitely appreciate what you were just saying, and you know, generally agree with that. I'm finding myself kind of just thinking through this whole thing, and I guess an outstanding question related to the quick math that Commissioner Gonzalez did is how many of those locations could have been further away. And I guess I am also still thinking about this in terms of, if we're setting the rules, they should be durable rules that we are making very few exceptions to. And I do get that there needs to be an opportunity for variance or whatever, but I guess I'm also thinking, if we're saying that X is the distance that is most protective, then why, I don't understand. I guess I can't really imagine a scenario where something closer, even if it's 50 feet or whatever, somehow is better than the 50 feet further away. So I'm wrestling with this in terms of, if we set whatever the number is, if we set it, I feel like that should be, as I was saying before, the thing that operators aim for as the baseline or above. And then if it's going to be less than that, it has to be for a very, you know, just extraordinary set of circumstances. That's where I'm sort of coming from this. And I'm not opposed at all to the 2,000, you know, but I'm also just kind of thinking through this, and given those numbers that we're looking at, you know, I guess there's a couple of questions. You know, one is, how many of those could have been done further away, but also how much of a burden is a 30% rate potentially of variance requests, you know, on staff. And given that we're a professional commission, it wouldn't bother me any if we're listening to a variance every single day, but I guess I'm just trying to think through those different things in terms of the long-term aspect. You know, would we rather have something that sticks and that is understood, that if we bend, it's going to be for a really, really good reason? Or do we want to have something that's like more, you know, further out, but then we make a lot more exceptions? And then does that really uphold the notion of a further out distance? So I'm just kind of throwing that out there for further discussion.
Thank you, Commissioner Nanjapa. Director Murphy.
I'm happy to offer a little bit of perspective in terms of how, I mean, staff approached it in a tiered way. right, in terms of varying levels of distance receptors. And I think that that reflects the hierarchy, the mitigation hierarchy is what I've called it in 181 around avoid, minimize, mitigate. And distance is one tool in that suite of options, but it's not the only tool. I think it's simple to measure, it's simple to calculate, it's simple to do that. And after that, it requires a more case-by-case analysis to look at what are the tools. Once you've chosen the location, right, like you're out of the avoid space and you're fully into minimizing and mitigating. And so is distance the right thing to minimize, mitigate, or are emission control devices, are sound walls? And so that to me is what the historic practice has been in terms of wrestling with what are the BMPs that are required in exception or buffer zone locations. And now I'm talking about existing rules, not prospective rules. And so that is one of the ways to kind of think through either a tiered approach or why something can be protective, as protective at, you know, the 1100 feet as it is at 1150. And I'm picking numbers that aren't really part of the conversation to just keep it a fairly neutral point. I don't know if that helps or not, but that's certainly the framework for staff's approach in terms of looking at tiering and hierarchies and which issues should go to the commission itself for a decision versus via staff level, this location's okay, and here's how we would recommend BMPing.
Thank you, Director Murphy. Further thoughts, Commissioner Nanjapa or other commissioners?
Yeah, thank you, Mr. Chair. I appreciate that explanation as well. I guess part of me is sort of thinking in this realm of you know, reasonable and necessary, you know, protections for public health, safety, welfare, environment, and wildlife resources. If it's possible to further mitigate the emissions or the noise or the whatever, why wouldn't we do that at the durable distance as opposed to if they're bringing it in closer? Or, you know what I'm saying? I'm kind of struggling with if that's something that's possible, wouldn't we want to require that more generally? Or, you know, does that have to be a condition of approval? And I guess I'm also thinking of this, as I was saying, with respect to durable distances or regulations in terms of, we do now have the ability to deny permit requests, permit applications. And so maybe we need to think about whether those additional mitigation measures are really, you know, going to add some sort of major benefit to the mission of SB 181, or whether that's just a circumstance where we just can't approve. So I don't know if that entirely makes sense, but I guess I'm thinking about this in terms of, you know, if we're setting a setback, I kind of agree with Commissioner Gonzalez that it should mean something and it should be fairly hard, and fairly hard to bend. So what would be the conditions that would be required if we were going to bend them? And if those conditions are possible, why don't we, you know, require them anyway, because they are, you know, additionally beneficial. So I'm just kind of thinking through that.
Thank you, Commissioner Nanjapa. I mean, I can take a swing at your proposal or your thoughts or the inquiry lane. You know, I just go back to the fact that I was trained by the great oil and gas location assessment staff with the objective criteria. And often it is site specific in terms of whether a setback needs to be honored or whether it can still be protective, even if it's less than the setback distance. And it's dependent, and it is a site by site analysis with the operator agreeing to conditions of approval or suggesting best management plans. And so that's why I at least like the concept that the waiver language should be broad enough to allow us to evaluate things as they come in the oil and gas development plan. And I think that just as we learned and became more efficient at looking at permits under objective criteria, operators too became more protective and more able to obtain permits from that perspective. And I know that we're not creating that regulatory protocol with our 181 regulations, but it is sort of the thing that I can go back to inform at least my decision making and where I'm landing with regard to these thorny questions. Director Murphy, did you want to add any perspective on that?
I think there is something to be said for some of the current structure for commission setbacks, in that the 200-foot setback that currently exists is really hard. And so do we look at expanding that kind of in the realm that I think industry articulated well, the 500 space, right? And that is a hard. And then do we look at a 2,000 foot as something where the commission can look at the site specific receptors and conditions to evaluate whether 2,000 is too close? And does that, because philosophically, I mean, I commend you, Commissioner Gonzalez, for framing this up when we started this conversation of, do we philosophically need to agree on what the purpose of a setback is before we figure out what the setback looks like? And I've heard two very different strains of what the setback should be. And I think that there's a way to do both, recognizing that they function slightly differently within the rules.
Thank you, Director Murphy. Yes,
May I share my screen real quick?
of course.
Okay, I just did a quick little PowerPoint over lunch break I thought I'd share. I don't know, I've never done this before. Let's see. Can everyone see that? Okay, so this is the way I think about it, and I think this is what Director Murphy was kind of summarizing where I was going with this one view, and I acknowledge there's two competing views on how we can do it, and I look forward to potentially Director Murphy having better ideas than all of us and finding a way to marry that and find the best approach. But when I think about a setback, again, I think about it hard. I think about an area that you don't want to go to. You're under almost all circumstances are not going to allow oil and gas development unless there's an extremely compelling reason to do so. Then you got a much bigger alternative location analysis that says, hey, this is our site-specific review. Again, you better have a darn good reason for being in here, right? You better have a really, really well-vetted proposal and a lot of BMPs and a lot of protections and probably not a lot of waivers or variances on any of the other 400 series stuff in order to be able to permit within there. And so that's where I think of these in a tiered approach, right? And I think that if we go straight to the big one, if we go straight to out here and say everything falls into here, but you got to get waivers, I think that we're kind of ignoring the philosophical purpose for setbacks that I've proffered today, I guess.
Thank you, Commissioner Gonzalez, for working over your lunch hour and providing us with that information and that perspective. Commissioner Messmer.
Thank you, Mr. Chair. So in my experience doing land use, and I think Director Gibbs had mentioned it today as well, that there are opportunities in most land use regulatory processes for variances, because there's specific standards, there's specific zoning, there's specific situations that you put in place in order to, well, in some respects, to protect public health, welfare, safety. And yet there are numerous situations that I've been involved in where variances have come in front of me with, strong, compelling arguments why, doing it slightly differently or utilizing a different technology or, coming at it from a different approach actually makes sense, because when you're developing hard regulations, hard zoning, hard land use codes, hard setbacks, those are going to last for, some significant period of time and do not take into consideration, changes in, technologies and approaches and materials and, things into the future. And so, and the challenge is that if you're asking someone to create, a hard setback, then in my opinion, that hard setback, has to take into consideration the worst case scenario. And that's going to be a significantly, potentially bigger setback than if you had some variance in there in order to allow technologies, best management practices, and, conditions of approval. And so I'm struggling here a little bit, because while Commissioner Gonzalez, I appreciate your PowerPoint, I think that, in my opinion, what an ALA is it's a planning tool. It's a planning tool to try to determine where the best site is for a particular situation based on the minimum standards that we set, right? And so the minimum standards are, this is what you have to do. And then you try to figure out a site that is the best site, not within these areas where you can't go or what you can't do. And so I see it totally separate from a setback piece, besides the fact that it interacts with the standards that say you can't go here. And so, I guess I don't see that as close an interaction between the two things as I think you do. I mean, I see where you're coming from, as far as utilization of the ALA, and I think it's an incredibly important planning tool. And so, I'm a strong advocate of the ALA in almost every application, because I do believe, we've heard testimony say that, if there's a situation where an ALA is done and it's in in an area that's really not around anything else, then it's a very simple ALA. This is the best place. If it's in an area with lots of different receptors, and that hits a bunch of different conditions where you really have to hyper analyze the particular situation, then it becomes much more difficult to do in order to find the most protective site. But I do think that it's not outside the norm of land use planning to have a standard, understanding that standard is developed for very specific reasons. And those reasons could be, to help mitigate impacts to public health, to help mitigate impacts to welfare, to avoid nuisance pieces. And so at a minimum, this is what actually, accomplishes that based on best available science. But yet 5 years down the road, there's a technology that may allow this site to actually come in over into this area, utilize these techniques, and be able to accomplish the exact same thing. And so I do think we need to make sure that we are nimble in the development of this process that takes that into consideration. And so, that's my ramble on that.
Commissioner McGowan.
I feel like the more we talk about it, the more I have to think about things, and it's harder to make a decision. But I do think the setback for me is a blunt instrument, but it's the most impactful instrument that we have at our disposal, and it's the one to me that most directly addresses health, welfare, safety environment. And it's the tool that best provides the commission a mechanism to address a lot of the impacts that we heard from people who testified, saying this is how this activity impacted me, my life, my quality of life, my health, my living experience. And so I hear the argument for it's a hard and then for the soft. And having been in a regulatory environment, you regulate to protect, but you also regulate knowing that there are going to be instances where folks who are being regulated, they're regulated, are going to come to you with some pretty creative things that are good ideas that are outside the regulations that you set up. And I think that we have to provide that space for operators, because I think it's important, and I think when given the opportunity, people who are the folks that are regulated can be very creative and responsive. And so again, I don't have the answer, but I'm hearing what Commissioner Gonzalez is saying. It's just that I think that for me, the setback is a really important tool, and I think is the tool that we use to set the foundation and the groundwork. But I also think that we have to allow space for variance, because I think we are going to see some creativity, and I'm hoping that creativity is also going to include a lot of community engagement, where the community says, we hear what you're struggling with, here's what we're struggling with, here's the compromise, or here's what we think is still protective and still fits into the fabric of our community. We're looking at things around tolerance and risk and protection, and we have to figure out how to marry all of these things together.
Thank you, Commissioner McGowan. Director Murphy, I think that what this is showing is empathetic and heartfelt commissioners struggling with thorny issues. And so we can all agree on that. I think we have given some direction to staff around some of these issues. I personally have appreciated the debate and the dialogue amongst commissioners this afternoon, and I don't really want to give more direction. I want to think about it more. I think probably all the commissioners feel that way. I think that if staff could think about it as well, having heard from commissioners, perhaps provide some ideas. I would just want to keep them in the idea level. I want to do the same. I want to take back my notes and go over them, and because I think no one is wrong here, and no one is perfectly right here. Again, thorny issues. We've talked a lot about putting the puzzles of this rulemaking together, and I personally, don't want to define out, okay, the setback's got to be this at all times, without sort of thinking about some of the other things that we've heard from some of the other commissioners. So I think I've given you direction that's clear as mud, and I apologize for that. But unless other commissioners want to continue to weigh in, I would suggest we sort of park the setback train. Everyone think about it. We're going to come back and be thinking about all of these things as they combine together after we get through 200 series. And so there will be additional time for discussion and debate about these issues. And again, I'm not trying to cut anybody. Commissioner Messner, please.
Thank you, Mr. Chair. And I appreciate that. And I think it's always good for us to take a little time to review our notes and think about stuff. I think if I was in staff's position, I don't think I would have enough clarity to even provide ideas, because I'm not sure that we've provided that clarity right now. And so I wonder if maybe we shouldn't just go down and figure out what we do at least have a majority of agreement on, so that at least those can be for sure in the staff's ideas. And then I know that there's going to be one or two pieces that we may need to think about, and we don't have enough majority or consensus to actually agree on at this point. But, so far what I've heard is that, it's a 2,000-foot setback. It's from one or more building sites, from 2,000 feet from schools. I think, and you guys tell me if I'm wrong, but we've got consensus on how we're going to measure these things. So it's from working pad surface to building, and then from facility boundary on schools to working pad surface boundary. We've got, so really the topic of debate right now, or the thing that we need to think about, appears to be the waiver piece, the exception piece, and how it's utilized. I think is the only thing we're not, at least in majority of agreement right now. Am I missing anything?
Mr. Chair, oh, sorry.
Yep.
So thank you. So for the schools, I think people gave me a couple of things to think about, and I'm good with the 2,000 feet, no waiver from a school board, but the ability to contemplate a variance if it comes to the commission for discussion. Is that what we're saying? And I think we might have, if Commissioner Nanjapa is in the same place, I think we might have that piece
Sure.
consensus.
Thank you, Mr. Chair, and thank you, Commissioner McGowan. I think so. And I just want to, in case it wasn't clear, I completely understand that there needs to be a process for variances, for exceptions, et cetera. And there's always going to be a case-by-case situation to consider. But I guess what I'm thinking about, and, is if we're 2,000 with variances, exceptions, et cetera, and ultimately we average out to 1,800 feet, then why don't we just have 1,800 feet as the hard setback? And then, kind of look at other exceptions from there. So that's kind of where my mind is at with that. But like I said before, I'm not opposed, to the 2,000. I think, frankly, if I wouldn't be called arbitrary and capricious, I'd say a mile. But, I think I'm just kind of thinking through this in terms of the reasons for the exceptions, variances, waivers, et cetera. And I appreciate all the reasons that folks are giving. But I'm just sort of thinking, is it here and we keep inching down for various things, or is it here and then, depending on certain things, we just make people go further away?
Other commissioner input? Commissioner Messner.
So I hear what you're saying, Commissioner Nanjapa, and that's why I think initially I was at 1,500 feet with the exception piece, but utilizing the very high extraordinary standard for variances, and ultimately, these things all come to the commission for review. Ultimately, we're still applying our interpretation of what is protective of public health, safety, welfare, the environment, and wildlife resources. And I think ultimately we decide when variances get approved. And so if those variances are never, if the variances are, often, or if they're somewhere in between, that ultimately is our decision. And so thinking about that and realizing that the five of us will not always be seated in these seats as well. So, I mean, I think that's important to think about too. So, I mean, I see both working, to be honest with you. And I think I see them both working equally well and still being protective. And so I'm not hung up one way or the other. But as we're looking at it right now, I do think that the 2,000-foot setback with the exception and some limited abilities for variances, you know, based on site-specific situations, I think, and I think it could work. So.
Thank you, Commissioner Messner.
Sure.
Director Murphy.
I think staff has enough to get started, for what it's worth, and to come back and see if, you know, version 2.0 appeals, recognizing the diversity of input, the diversity of scientific perspectives, studies, distances, and information, and the importance of the setback as a tool, but not the only tool when you look across the rule sets.
Thank you for that, Director Murphy. I appreciate that. I appreciate that some of the direction may be clearer and some may be less clear. I think that allowing commissioners to think on this thorny issue, I don't think it would be fair for us to try to say, okay, we just solved the setback issue in a half a day. And so I think sleeping on it and giving staff a chance to think about it, you know, I want to think about it, and then coming back when we get into deliberation of the rule set as a whole and looking at this issue as a part of the rule set as a whole, I think will help be more informative, and maybe we'll be in a clearer mind for that. So with that, unless there's objection from commissioners, I would suggest that we, for the moment, close deliberation on 600 series, perhaps take a short break to give staff a chance to get ready for what is next on our agenda. This is part of the endurance race, so we're moving directly into 200 series. So why don't we take a 15-minute break and come back at 2:18, and that'll give staff a chance to collect their breath, and commissioners as well. Thank you, everybody. We'll wait for staff to get ready. All right. All righty. Director Murphy, I believe the floor is yet again yours. And we really apologize by pulling you into 600 and giving you only 15 minutes to pivot and be ready for 200.
Thank you, Chair. At the same time, each one of us is doing that same jump, right? So I think it would probably be best, and I'll let Mimi work on getting slides queued up while I say this, to talk a little bit about what is 200. We've thought about 300 as permitting, and as I described yesterday, what information comes to the commission about how an operator proposes to comply with the standards set forth in 400 and 600. We've talked about 500 as, and for me, the context is it's how you as commissioners make decisions and conduct your business. I have, in my more cavalier moments, referred to the 200 series as kind of the hardware drawer, because it's a compilation of a number of different rules that really govern, in my estimation, the interactions between staff, the commissioner, staff on the commission, operators, local governments, and others. How do we receive information, file information? How do we track who's responsible for what information? And so it's an interesting mix of rules, but generally kind of has overarching responsibilities in terms of these less permit specific or location specific rules, and more generally about how do operators and staff work together, or not work together, but how do we share information between different folks. So how is the work getting done, getting filed, getting documented, getting communicated? And it's a little bit different from so many of the other rule series to me in terms of those ones. It's easy to understand how 300 feeds into 5, 4, and 6. And this one's a little bit different. It stands alone in some ways. So with that, next slide, Mimi. So some of the key rules and rule changes that have received a significant amount of attention from parties, and a couple that are just critically important to staff as well. So Rule 201 has gotten a lot of attention. It's a bit of a carryover from the wellbore integrity rulemaking. So I'm sure Commissioner Mesner and Chair Robbins will remember that dialogue. Again, the point is to ensure that operators ensure compliance by their contractors and subcontractors. And to me, this has been the expectation and continues to be. And the changes here are meant to clarify and ensure that nobody would understand it differently. Staff thinks we struck the right balance in terms of the language we've incorporated. Rule 208 garners lots of attention because of its topic, right? Chemical disclosure. It's a carry forward rule. We've made some changes to it and some improvements to it. I think the piece that I want to flag in Rule 208, and Ms. Stanzik will go into greater detail about how the rule operates and how staff has proposed it should continue to operate, is in the conversation around the statewide chemical ban that we initiated as part of the 400 series conversation, received some really positive feedback from industry on. I need to kind of close the loop on that conversation. But I think some of the parties have suggested that this is the appropriate location. This Rule 208 is the appropriate location for any sort of kind of statewide chemical ban. Staff sees it a little bit differently. We think it fits better in the 400 series where you're thinking about the on-site operations. So I think philosophically, most folks are aligned on the concept, but if you hear about it here, staff's perspective will continue to be great. Let's put it in the 400 series now. Rules 209, 210, and 211 are important rules that govern how the commission can respond in the event of an incident, how the commission can require tests or surveys to verify whether there has been an issue or is not an issue, how do we monitor compliance and corrective actions, and then how do we deal with something that's really creating a significant threat. And for the most part, 209, 210, and 211 have been carried forward from existing rules. I would say that staff has modified them to some degree to clean up, to clarify, and to conform to 181. Again, I think that these are largely tools that exist today and we think are important to modify in light of some of the changes of late that we might be talking about called 19181, but largely I think that the premise is currently existing in rules. So lastly, and this to me is probably the most important rule change proposed in the 200 series in my estimation. And so it's solely my perspective. I think other people will feel differently about it, but from my perspective, Rule 218 for the first time allows our commission to document the transfer very clearly, very cleanly, and with precision as operators trade assets, right? This is an important conversation. Operators should and need to be able to transfer assets freely, but we need to know when it's happening, what's happening, and what's going with it, and who's responsible for it. That provides clarity to the public, local governments, staff, and also helps ensure that staff is able to pursue the right person for compliance. This rule, without this rule, there is an enormous administrative burden on staff when we're in the context of a transfer. And it's because operators, I think, send us kind of the high level, typically send us a very high level view of what's been transferred, but not getting to the level of detail. And Jane will go through this in a little bit more specifically, or Ms. Stanzik will go through this more specifically, but we need a granular level of data about what is being transferred to make sure that our system functions properly, to make sure that we are pursuing the right person on the right issue at the right time. And that's something that we have had to absorb at the staff level very often, and it has led to conflicts and challenges and delays. So this rule is very important to me, and I know that Jane or Ms. Stanzik will talk through it in greater detail. And with that, I would say next slide. There are 5 changes that staff has noodled on in the intervening time between August 17th and September 9th that I wanted to draw to the Commission's attention. This first change in Rule 206, we have proposed to resolve some stakeholder concern around our overlap with OSHA. I think that Mr. Minor, AAG Minor, is the right person to ask questions about on it, but again, it's responsive to a stakeholder concern that was brought forward, and we think it's a good idea. Next slide. Rule 208, oops, can we go back one? Sorry, great. So Rule 208B, as we read through the rules as we were preparing for hearing, we realized we didn't, or we inadvertently dropped or didn't clearly articulate what information we would need on a Form 41 to be able to process it. So this to me is a fairly administrative change, but it's an important one in terms of setting out our expectations for the form processing. And as you've heard somewhat ad nauseum, we are a forms-driven agency, so it's important to get this right. Next slide, please. Change to Rule 219. The language change proposed here is to make sure there's consistency between staff's 200 series rules, the enforcement rules, and the 500 series, and then the financial assurance rules and the 700 series. So I think about this as very much in the clarifying space. Next slide, please. Rule 220, we have taken another look at the intersection kind of on gas storage and how we're dealing with it, recognizing that there's federal authority, and we wanted to provide some clarity about how a gas storage facility would be documented and its federal approval status. So again, I think this is more, I don't think this is a huge substantive change, but I think it's a good clarification and improvement. And that takes me to the next slide. And the last of the 5 changes that staff is proposing from the August 17th draft to today is a proposed change to 223. And this rule is driven by the ongoing conversations between staff and some of the midstream operators, and in recognition that some of the information may need to be maintained somewhat confidentially as appropriate. I don't think we've gone 100% to where the midstream operators have asked us, and I'm sure they'll tell you more about their position, but this is what staff recommends as an improvement on the rule, recognizing the concerns that we've heard. And with that, my last slide, so you're at the benefit of not having to hear from me anymore, I'll walk through who's going to talk about what for the remainder of staff's presentation. I will hand it over to AAG, Mr. AAG Minor, to talk about some of the legal pieces. The 200 series does have an intersection with some important legal pieces, and so he'll walk through that and also some of the OSHA. Ms. Danzig, of course, our incredible person who lines up how the rules function and catches things like, hey, we have a form here, but we haven't told them what we need on it. She'll walk through a number of the detailed provisions around how the rules function in the 200 series and what they're designed to do. Mr. Leonard will talk about Rule 213 from his compliance lens, and then we'll close out today with Ms. Larson talking about 223 and the disclosure pieces. So with that, I will hand it over to AAG Minor to get us into the weeds on these important rules series.
Thank you, Director Murphy. As Director Murphy explained, I will be providing an overview of several 200 series rules that are primarily legal in nature or that parties have raised largely legal questions about. The first rule I will discuss is Rule 201, which frames the general standards for the scope of all of the Commission's rules. Staff made relatively minor edits to most of the subparts of Rule 201 and also consolidated some other general standards about the scope of the Commission's rules that were previously found elsewhere into Rule 201. One notable change is in Rule 201B, where staff have proposed to reframe what used to be Rule 320, governing liability, as a general rule governing compliance. As Director Murphy noted, Rule 201B codifies the longstanding expectation that operators are responsible for ensuring compliance with the Commission's rules by their contractors and subcontractors. Codifying this expectation in the Commission's rules was one of the recommendations provided by the State Oil and Gas Regulatory Exchange when it reviewed the Commission's wellbore integrity rules. However, given its broad scope, staff determined it was more appropriate to make this change during mission change. Some parties have raised questions about proposed Rule 201C, which has been amended to clarify the Commission's relationship with local governments in light of the changes made by Senate Bill 19-181. Staff's position is that Rule 201C correctly describes the nature of that relationship for the reasons that I described during staff's 300 series presentation. In the interest of time, I will not repeat those reasons now, but I am of course available to answer questions about staff's positions on those legal issues. Similarly, I am available to answer questions about the nature of the legal relationship between the Commission and tribal governments, which is outlined in Rules 201D and E and has not been substantively changed in the mission change rulemaking. Finally, I would like to briefly highlight Rule 201G governing incorporation by reference. Incorporation by reference is a somewhat confusing requirement of the Colorado Administrative Procedure Act, found in Colorado Revised Statute, Section 24-4103, Subpart 12.5a. In the interest of transparency, the Administrative Procedure Act requires that agencies make clear where members of the public can access codes, standards, guidelines, or rules from other agencies or national organizations when those codes or standards are referenced in the agency's rules. It also provides certainty to the regulated community by locking regulatory standards in to the version that was in effect at the time the agency adopts a rule, rather than allowing an agency's regulations to automatically update to a newer version without a public process, whenever the outside entities update their own standards. You've already seen many examples of incorporations by reference throughout the other series of rules that you have reviewed over the past few weeks. Next slide, please, Ms. Larson. Staff proposed only minor changes to Rule 204, which governs the Commission's inspection powers. These changes were generally intended to provide better clarity to the regulated community by using terms that are defined in the 100 series rules. Consistent with its longstanding practice, the Commission's field inspection staff will continue to coordinate very closely with our federal agency partners and will abide by all federal requirements while conducting inspections on federal lands. I would also like to highlight that the Colorado Court of Appeals recently held that Rule 204 does not violate the Fourth Amendment to the U.S. Constitution or Article 2, Section 7 of the Colorado Constitution. That is because the Commission's inspections fall within the administrative search exception to the constitutional requirement to obtain a warrant. Next slide, please. Staff proposes to move current Rule 207, which authorizes the Commission to require operators to conduct test or surveys to identify waste or pollution, to Rule 209. A lot has changed since the Commission adopted current Rule 207 in 1952. And accordingly, staff has proposed several changes to update the rule to conform to the statutory changes made by Senate Bill 19-181. First, staff has proposed that the Commission delegate the authority to require tests and surveys to the director because staff are generally better positioned to make technical determinations about what types of tests and surveys are needed, and because immediate or imminent risks may require rapid action. Second, staff has proposed a few changes to align the language of Rule 209A with Senate Bill 181. It is staff's position that it is well within the Commission's powers under the Oil and Gas Conservation Act and the Colorado Administrative Procedure Act to delegate to its staff this kind of authority over a technical matter that may require rapid action to address an imminent threat. In fact, this is the exact category of administrative action that the Oil and Gas Conservation Act contemplates the Commission will delegate to its staff in Section 104.5, Subpart 2, and Section 106, Subpart 2. Staff also proposed a fairly significant new rule, 209B, which allows an operator to seek an expedited appeal to the Commission of the Director's order requiring the operator to conduct a test or survey. This creates a new procedural right that did not exist under the Commission's prior rules. Rule 209B guarantees that the regulated community will receive due process and full procedural protections if and when the Director orders a test or survey. It takes advantage of Senate Bill 19-181, creating a full-time commission, which means that you, as commissioners, will be meeting frequently enough to quickly address this category of expedited appeal. Next slide, please. In this slide, I've modified a diagram that you might remember from my 300 series presentation to show the specific procedural protections that are afforded to operators under proposed Rule 209. First, as I mentioned earlier, Rule 209 is a delegation of the Commission's authority to the Director. The Director, like the Commission, is constrained to exercise only those powers authorized by the General Assembly in the Oil and Gas Conservation Act. Second, some parties have raised concerns that Rule 209 is not consistent with the responsible party provisions of the Act. Staff does not share this concern. As explained on page 25 of the Statement of Basis and Purpose, prior to ordering the operator to conduct a test or survey, Rule 209A requires the Director to determine that there is a reasonable cause to believe that an operator has taken an action that impacts or threatens to impact public health, safety, welfare, the environment, or wildlife resources. This is, in other words, a responsible party determination. A determination that there is reasonable cause to believe that an operator has taken an action that violates the Act. Third, as shown in the diagram, the Commission has provided additional due process protections beyond what is required by statute by authorizing an expedited appeal directly to the Commission rather than the ordinary intermediate appellate process before an administrative law judge or hearing officer. This direct appeal process affords operators the full notice and opportunity to cure required by the Administrative Procedure Act in Colorado Revised Statute Section 24.4.104, Subpart 3A, before the permit is modified. As you heard over the past 2 weeks in the discussions of the 500 series, all Commission hearings involve notice, a reasonable time period to prepare, and an opportunity to submit written filings, which meets the requirements of the Administrative Procedure Act. Next slide, please. Many of these procedural safeguards are also relevant to proposed Rule 210, governing corrective actions. Staff have proposed relatively minor changes to current Rule 208 to add more details and clarity and to better align with Senate Bill 19-181's changes to the Commission's mission and statutory authority. Consistent with its current practice, the Commission's field inspection staff will continue to coordinate closely with our federal partners on corrective action requirements, including ensuring that no corrective action interferes with any federal timing stipulations. The fundamental purpose of a corrective action is to allow an operator to work with the Commission staff to resolve issues without undergoing a formal enforcement process. There are numerous advantages to this framework, but the biggest advantage is that it facilitates rapid correction of potential threats to public health, safety, welfare, the environment, and wildlife resources, instead of waiting to address an issue until a potentially lengthy enforcement process is completed. As discussed on page 27 of the Statement of Basis and Purpose, Section 121, subparts 1C, 1A, and B of the Oil and Gas Conservation Act expressly contemplate this framework by discussing corrective actions that can be taken before an enforcement matter is resolved. Accordingly, staff does not agree with some parties who have suggested that Rule 210 does not comply with the Administrative Procedure Act's notice and opportunity to cure provisions. A corrective action is the notice and opportunity to cure a potential violation of the Act before formal enforcement action is taken. Staff believes the proposed language of Rule 210A appropriately limits the Director's discretion by adopting a reasonable cause standard. The current language of Rule 208 does not identify what standard the Director will apply when requiring an operator to take corrective action. Therefore, the revised language provides additional procedural safeguards beyond what currently exists. Staff believes that reasonable cause is the appropriate standard because it aligns with the statutory language in the Oil and Gas Conservation Act's enforcement provision, which is Section 121, Subpart 4, and with language in current Rule 901C that governs similar determinations. Staff have proposed a new rule, 210B, to codify existing practices around submitting Field Inspection Report Resolution, or FIRR forms. FIRR forms document that a corrective action is complete. Staff believes that codifying this practice in the rule will improve transparency by allowing local governments and members of the public to verify that any issues identified during a field inspection have been resolved. Next slide, please. Staff have proposed to move other parts of current Rule 208 to a new Rule 211. Current Rule 208 provides that the Commission will require operators to plug and abandon wells that are no longer used or useful. Staff have proposed to expand the procedural safeguards provided by this rule by requiring a hearing before the Commission issues this type of order. Requiring a Commission hearing also allows for greater transparency and public involvement because a local government or a mineral owner that believes a well should be plugged or abandoned may petition the Commission to hold a hearing on the matter. Because of Senate Bill 19-181's changes to the Commission's mission and statutory authority, staff proposed to add additional criteria for when the Commission may order a well to be plugged and abandoned, when necessary and reasonable to protect or minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources. Staff also maintains the current criteria that the Commission may order the plugging and abandonment of a well that is no longer used or useful. Some parties have suggested that the Commission define used or useful in this rulemaking. The term used or useful has been in the Commission's rules since 1954 without a definition. Staff agrees that defining these terms could provide better clarity to the regulated community and other interested parties. However, staff believes that it is more appropriate to address the definition of these terms in the forthcoming financial assurance rulemaking, which will be more focused on comprehensively reviewing the Commission's rules that apply to the end of the life of a well. Staff believes that taking up the definition of used or useful in that upcoming rulemaking is appropriate and will not cause undue hardship to any party. In addition to the relatively minor changes staff has proposed in 211A, staff have also proposed to add a new rule, 211B, governing location closure. When the language in current Rule 208 was adopted in 1954, the Commission was more focused on regulating downhole issues. Since that time, the General Assembly has repeatedly expanded the Commission's directive to regulate the surface impacts of oil and gas operations. Staff therefore believes it is appropriate and in line with Senate Bill 19-181's changes to the Commission's mission and statutory authority to adopt a parallel standard to allow the Commission to order the closure of a surface location after a hearing. Consistent with current practice, the Commission's staff will continue to coordinate closely with our federal partners in all enforcement matters, especially a matter with such gravity as ordering the closure of an oil and gas location or ordering an operator to plug and abandon a well. And consistent with Senate Bill 181, staff will also coordinate closely with our local government partners in these important matters. In fact, the new requirement for a Commission hearing will allow an additional avenue for formal input from federal partner agencies and local governments before the Commission issues an order. Next slide, please. Finally, I would like to briefly touch on Rule 212, which governs the isolation of coal seams. Staff did not propose any substantive changes to Rule 212 in the mission change rulemaking, although some changes were made during the wellbore integrity rulemaking. However, some parties nevertheless discussed Rule 212 in their written filings. Accordingly, I will just briefly note that Rule 212 implements part of the Commission's statutory authority that you might not have heard as much about. What we commonly refer to as the Oil and Gas Conservation Act is found in Article 60 of Colorado Revised Statute Title 34. However, Article 61 also creates some substantive obligations for the Commission to ensure that coal mines and coal seams are adequately protected from oil and gas operations. Rule 212 implements Article 61 by requiring the isolation of coal seams. I will now turn it over to Ms. Jane Stanczyk, who will continue staff's 200 series presentation.
Thank you, Mr. Minor. Can everyone hear me all right? Thank you.
We can.
Thank you. Well, good afternoon, Commissioners. I'm Jane Stanzik, and I still manage the Permit and Technical Services Unit. Operators buy and sell wells quite frequently. Since 2010, an average of nearly 7,600 wells have been transferred annually. The current rules require operators to file a Form 10 within 15 days after the operator of a well or another oil and gas facility has changed. The rules authorize the director to withhold approval of the change until the new operator has provided any additional financial assurance required for the new wells and facilities. Other than that, the processing of the Form 10 is an administrative action that changes the Commission's operator of record for the wells and facilities submitted on the form. For years and years, staff processed the operator changes according to the rules, only verifying financial assurance. This practice, though it was in compliance with our rules, had a serious consequence due to related facilities. Next slide, please. This slide illustrates what I mean by related facilities. Here's an oil and gas location with a well and a pit. Each of these three items is a separate facility. Each one is uniquely identified in our database. Each one has a status. Each one has an operator of record, and each one must be listed separately on a Form 10 to change the operator. So when an operator buys a well, they submit that well on a Form 10 and the operator of record is changed. If they did not list the location and the pit on the form, the operator of those facilities does not change. When our field staff conducts an inspection, they rely on the operator of record in our database. So if only the well was listed on the 10 and the inspector visits this location, the inspector will notify the operator of the well of any issue with the well and the operator for the location of any issue with the location. You can imagine that the previous operator of the well would not be pleased to receive a corrective action required inspection for a location that they thought had been sold. Over the years, with wells being bought and sold multiple times, this disconnection of related facilities results in instances of a location or a pit having the original operator and the well having its third, fourth, or even fifth operator. To address this unintended consequence, staff has taken the initiative to research and identify every related facility for every item listed on a Form 10. Though not required by rule, staff, when they identify a missing related facility, contacts the buyer and the seller to discuss these missing facilities. When a purchase involves hundreds or even thousands of wells, these issues can be numerous, and staff's review is so time-consuming, the approval can be delayed for months. Next slide, please. This is the very same location several years before the transfer, when there were 3 pits on the location. The seller of the well may be the third or fourth operator of that well, and those pits may have been filled in by the original operator, meaning the seller may not know they were ever on this location. This situation is often further complicated when the operator who filled in the pits did not follow the pit closure rules, meaning the pits still have an active status and the operators now have a compliance responsibility they were never aware of. When staff contacts the buyer and the seller in this type of scenario, which is unfortunately not uncommon, both parties may look to the original operator as being responsible for those 2 old filled-in pits. If that operator refuses to accept responsibility, or as is often the case for an older well, is no longer in business, there is an impasse that can result in those pits being orphaned and becoming a liability of the state. The current rules have no way for staff to resolve this situation. Staff can delay the approval of the form and hope that the operators, the buyer and seller, come to some agreement. But since the form was filed after the sale, the buyer is already operating this well. Next slide, please. The proposed new rules are designed to address all of these issues. Overall, new Rule 218 proposes a fundamental change from a simple change of operator of record to a transfer of operatorship of facilities, meaning the permit or license to operate a facility and the associated compliance responsibility is clearly being transferred. Proposed Rule 218 also includes several procedural changes. There will be a new form, the Form 9, removing the current double duty of the Form 10 as a change of operator and certificate of clearance, which I'll cover a little later in this presentation. The Form 9 will be filed 30 days prior to the anticipated sale of the facilities rather than 15 days after. And to address the challenges of related facilities, the new rule defines a new term, transferable items, and requires them to be listed on the Form 9. In addition, the Form 9 will include an attestation of compliance responsibility for each of the transferable items, either from the current operator or from the new operator or even from a previous operator. In this way, every related facility will be accounted for and a transfer will not result in orphaned facilities. Next slide, please. This slide shows the list of transferable items included in Rule 218. It specifically includes all the facilities related in the Commission's records, placing the burden to catch the related facilities on the operators. In addition to related facilities, the transferable items include unresolved spills, open or active remediation projects, unresolved field inspection corrective actions, and unresolved enforcement matters. These are often extremely contentious issues when facilities are transferred. Next slide, please. This slide shows two database search results for facilities related to the well in each group. Related facilities are readily available in a database search on the Commission website. Next slide, please. When the transfer is final, the seller will file a Form 9A. Staff can then complete the review of the Form 9 and approve it in a more timely fashion. If the transfer is terminated, the buyer will file a Form 9A and staff will withdraw the Form 9. This will improve the efficiency of the transfer process. As mentioned, a buyer may take possession and begin operating a well or facilities prior to the approval of the transfer. If the buyer has not yet provided additional financial assurance required for their new wells, they are operating them without adequate financial assurance. Should this occur, the proposed rules authorize the director to have those wells shut in. In addition, because the new procedure requires a Form 9 to be filed before a sale is final, the operator may request confidentiality of it until the Form 9A is submitted. Next slide, please. The operator of a new oil and gas well files a certificate of clearance to designate the entities authorized to transport the oil and gas from the well. In the penalty phase of an enforcement matter, the Commission can suspend the operator's certificate of clearance, meaning no products can be transported or gathered from the operator's wells. The transporters and gatherers are required to have a copy of the Form 10 for the wells they service. If the operator of the well adds or changes a transporter gatherer, they file a new Form 10. In the new procedure for transfer of operatorship with a Form 9, after that transfer is approved, the new operator will file a Form 10 to designate their transporter and gatherer for that transferred well. Next slide, please. Oh, that's not my slide. I think we're having a technical difficulty.
Sorry, give us one moment and let me see if I can retrieve that slide, Ms. Danzig.
No problem. Mr. Leonard, was that your slide?
While we're on hold, and this is atypical, but can I ask Ms. Stanzik a question? The question on that transfer of ownership, it seems like that perhaps we have quite a few well locations where the well has transferred, but the related facilities have not. Is that accurate?
It's more common that the well gets transferred and the related things don't.
Okay, so I guess that was kind of my point. I said it backwards, but we've got a location in which we've got the former owner still of record for some things, and then the new owner of record for others.
Yep.
So it looks like the rule does a good job going forward in ensuring that when there's a transfer, all things transfer. Does the rule try to look backward to fix the current problem that we've got?
No. Though I will say, I mean, what we've been doing, though it's outside the rules, you know, the way staff just pours through everything on a Form 10, and we've been doing that for several years. It still does pop up, but you know, we've worked really hard to stop it from happening, and but no, the rule doesn't have a mechanism to maybe query our database and identify those instances where things are out of sync.
But so if we were to adopt the rule as drafted and an operator goes to transfer a well, but the operator did not have ownership of the related facilities, would the rule sort of flag that and the transfer wouldn't happen until they go straighten out ownership?
That's right. Exactly.
Okay. So in essence, it will be doing that. It just is as things transfer.
Exactly.
Thank
Yeah,
you, Ms. Stanzik.
we're not good. Nothing can go forward without getting it all cleaned up.
Thank you. We'll let you back into your slideshow that Mr. Leonard stole from you.
Okay, this is my next slide. Thank you, Miss Larson. Sorry about that. The proposed new rules define a principal agent as the operator's representative authorized to accept and be served with notice from the commission or from other persons authorized under the Act. And new Rule 205 codifies the long-standing practice of requiring operators to designate a principal agent. There are no other changes proposed for the requirements for operators to register with the commission and to designate agents. Next slide, please. In 1992, the commission created the Local Government Designee, or LGD, program to facilitate local government participation in commission matters. The local government designee is currently defined in the 100 series, and no changes to that definition are proposed. Next slide, please. The proposed new rules clarify and codify how a local government communicates their LGD information and what the LGD is responsible for. For local governments who do not choose to have an LGD, the new rules provide a way for them to submit an email address for notices. And for local governments that neither select an LGD nor provide an email address, the new rules allow staff to use a publicly available email addresses for local government notices. Next slide, please. As I mentioned in my 400 series presentation, the Commission relies on forms to obtain and process information from operators. The same is true for information from local governments. It is only with the Form 29s filed by local governments that staff will be able to send the required notices and to implement the requirements of new Rule 302F2 and 3. Next slide, please. Operators are currently required to keep complete and accurate records and to provide the Director and Commission access to those records. The proposed rules clarify these requirements with a list of record types to be kept. The proposed rules also update the information requirements by authorizing the Director to require electronic formats, enabling staff to stop accepting paper documents. To accommodate the frequent need for an operator to obtain data from a third party, the rules grant the Director the authority to extend the deadline in a rule or in a request. Next slide, please. To ensure clarity, the new rules include a definition of well records. The new rules do not propose any substantive changes to confidentiality for well records. The statute instructs the Commission to provide 6 months of confidentiality for sensitive technical information and data related to a wildcat or exploratory well. Our rules define a wildcat or exploratory well as any well drilled beyond the known producing limits of a pool. This allows an operator who has taken a significant risk to protect sensitive technical data from competitors. The new rules specify that when considering a Form 4 requesting confidentiality, the Director determines if the well meets the definition of a wildcat or exploratory well. It should be noted that approval for confidentiality does not allow the operator to delay any required reporting to the Commission. The due dates for all forms and reports are the same for all wells. The new rules clarify the requirements for chemical product records, and as Director Murphy pointed out earlier, they remove the potential jurisdictional conflict with OSHA regulations. Next slide, please. The proposed rules require the transfer of all records and all reports to a new operator. Some stakeholders questioned the need to transfer and maintain data that has already been filed with the Commission. Staff believes that operating any well or facility in full compliance can only occur when the current operator has immediate access to complete records for that well or facility. There have been instances of unexpected well events in which a new operator had very little information about their well and had to rely on the Commission's records to respond appropriately. It is for this reason that staff has proposed this addition to the record-keeping rules. The need for complete records is also the basis for the records maintenance timeframes. The timeframes are not dictated by the age of the records themselves, but by the status of the well or location. It would not be prudent to discard records after 5 or 10 years when a well is still producing or a location is still in use after 30 years. Next slide, please. Though short and simple, this is a powerful rule. Each rule that requires a specific report or form includes the due date for that report, but it does not mention the accuracy and completeness of the report itself. Though an operator files their reports on time, the forms can sometimes be inaccurate and incomplete. When staff initiates enforcement on forms and reports, a frequent operator response is, "But the form was filed on time." As proposed, Rule 207 maintains the fundamental requirement for reports to be accurate and complete, and it reiterates that they be filed on time. Next slide, please. The public's concerns about hydraulic fracture stimulation were addressed in a rulemaking in 2011, resulting in the development of the chemical disclosure rules. The proposed rules do not make any substantive changes to the overall chemical disclosure procedure. That procedure requires the service company that performs a hydraulic fracture stimulation treatment to provide certain chemical information to the operator of the well within 30 days after the treatment. Within 60 days after the treatment, the operator must file that information with the Chemical Disclosure Registry, or FRAC-Focus. FRAC-Focus was created in 2011 by the Groundwater Protection Council and the Interstate Oil and Gas Compact Commission. It is a nationwide, public, searchable registry for chemicals used in fracking. Recognizing that service companies sometimes consider this information to be proprietary, the rules provide a mechanism for them to request trade secret protection by filing a Form 41. The director may approve the request and designate the information as a trade secret, which means it does not have to be filed with FRAC-Focus. Next slide, please. Proposed Rule 208A broadens the list of entities that can request chemical product information and clarifies the specific circumstances in which a request can be made. To facilitate the disclosure, the current requirement for a health professional to file a confidentiality agreement has been removed. Since 2011, chemical information has been requested in 2 instances. Next slide, please. Current Rule 313B requires operators to register gas gathering systems with their associated compressor stations and gas processing plants, as well as underground gas storage facilities. In proposed Rule 220, the registration requirements are updated to require GIS data for the underground gathering lines. This GIS data will be protected in the same way the flow line GIS data is protected, by limiting the detail displayed on the website map and by requiring an LGD to file a confidentiality agreement for access to that data. Mike Leonard, our compliance manager, will present some more 200 series rules.
And just give me a moment while I queue up Mr. Leonard's presentation.
So while she's doing that, thank you, Ms. Stanzik, and good day, commissioners. When we get this queued up, I'm going to speak to you a little bit more about notices, or more to the requirements of notices, which is what this notice to director Rule 213 requires. Okay. Currently, there are several places within the rules that require notice be filed prior to operations taking place or after action's been performed. This draft rule simply explains that any required notice will be filed to the commission in the required time frame and with the required form. As I mentioned last week in the 400 series notices, they're automatically forwarded to the appropriate staff to allow for timing and planning of inspections or other work. In addition, some are also forwarded to local governments. The filing of these forms in an inappropriate manner may delay that notice getting to the correct staff member or that local government. For instance, operators have filed notices of corrective action completed on a Form 4 sundry when they should have used a Form 42, which we're no longer using, but or in cases where they provided notice on a Form 42 notice of other rather than the appropriate Form 42, such as notice of mechanical integrity test. So moving on to 213B, it's important to note here that emergency situation is a defined term within the rules. And this changes the current rule just a little bit because it spells out that the operator may provide verbal notice during an emergency situation to avoid delay in responding to that situation. But now they must provide that information in writing as well within 3 days. And with that, I'll turn this over to Hearings Manager Larson. Maybe.
There we are. Hopefully everyone can hear me now. Excellent. So I'm going to speak with you briefly this afternoon about our Rule 223. We have proposed a new Rule 223 that covers and addresses how we deal with confidential information that comes into the Commission. You'll see on this spread or on this table that we don't have a current rule that actually addresses the process by which staff and this Commission handles confidential information. In our current rules throughout, whether it be the 200 series or elsewhere, we have identified certain types of information that are confidential. And you heard earlier from Ms. Stanzik addressing, for instance, wildcat well information. In our current rules, we had highlighted that as a type of confidential information. And we've done that elsewhere, but we didn't have one rule that spoke to confidential information in general. So what staff is proposing is a process by which we would allow operators to present us confidential information, meet with staff to discuss whether or not this information is in fact confidential. And if staff agrees that it's confidential, then we would accept it, but ensure that it's maintained as confidential. And that may mean we either, the information comes in as partially redacted, or there's some other process by which that we are able to address and ensure that that information is kept confidential. We've also set forth in Rule 223B types of confidential information that we expect would be most commonly submitted to the Commission. This list is not comprehensive. There may be other types of information that come in. But we've identified what we feel to be the most common types of information that we would receive. As Director Murphy highlighted in her presentation, we've proposed to make a few additional changes to this list to add a few additional categories of information. And those categories of information were added after we received feedback from parties about types of negotiations potentially that would be confidential, and potentially that information would make its way to the Commission in the course of an oil and gas development plan or in other submissions that come in from operators. So that, in a nutshell, is what staff is looking to accomplish with Rule 223 and the confidential information. So with that, I believe I'm the last presenter. I'll wrap it up and hand it back over to Director Murphy.
Thank you, Ms. Larson. And I would note that we're on some number of almost 14 days of hearings, and this is staff's first super significant PowerPoint glitch. So I'm pretty remarkably impressed by the team on that front. I don't have much left in my tank to close with today, except to say that you all are troopers. Our stakeholders are incredible troopers, and we're happy to take questions on 200.
Thank you, Director Murphy. Just because it was the most recent slide that we saw, I had a question from Ms. Larson about the confidential information. And how does that play into, Colorado's Open Records Act and sort of the premises that we need to be cognizant of with that?
Yes, thank you, Mr. Chair, for that question. So within Rule 223, we have noted specifically that the information that comes in, we will comply with the Colorado Open Records Act. So for instance, in Rule 223B, the items of information that we've identified that we believe could be confidential, we have determined in working with our legal counsel, our assistant attorney generals, that the items that we've identified would be confidential information potentially under the Colorado Open Records Act. So we have taken that into account when drafting this rule.
And Mr. Chair, if I,
you want to add?
I have very little to add because, as you know, Ms. Larson knows this backwards and forwards, and I will just briefly point out that Rule 223B10 provides a nice catch-all so that if there was anything that we missed in 1 through 9 in terms of the categories of information that are confidential, Rule 10 is a catch-all that says anything else that meets the confidentiality provisions of CORA. So we think we captured everything. Obviously, the midstream operators helped us identify some things we'd left out, but we do have that sort of helpful catch-all in case we did miss anything in that list.
Thank you, Mr. Minor. Commissioners, are there questions for staff? Commissioner McGowan.
This is just a why do things happen in the order that they do question. It seems odd to me that the chemicals for fracking are put into frac focus after an operator starts versus before. So I guess maybe I'm not understanding the purpose of frac focus and the disclosure of the chemicals that are used, because it would seem more useful to let folks know ahead of time in case they had any concerns versus after they've already been operating for a while. So I was wondering if someone could just help me out with that.
Yeah, Mr. Leonard.
Yeah, so frac focus is designed to report what chemicals were used, not what chemicals were brought on location. So they may bring extra and not use it. In fact, that's frequent. So it's designed to report what was put down the hole during the frac, not what was brought on location.
And Mr. Leonard, in follow-up, would an operator know? I mean, I assume they would know before they stick it down the hole because they've mixed it up. But would they know, 30 days ahead of time? How do they develop up what their chemical constituents are, and when would they know that?
So they all have a recipe. The service companies have a recipe based on various parameters of the well, and each well may be different. They may be all the same on a pad. A lot of times it's just what it looks like when, so they'll have the recipe, but when they pump that first stage on that first well, they know, oh, we can back this off, or we need to increase, we need to back this surfactant off, or we need to add this surfactant because the formation's a little tighter than what we thought. So that's where that leeway comes in.
And go ahead, Mr. Minor.
Yeah, if I may, Mr. Chair, thank you. I want to clarify that the reason that Rule 208 is an after-the-fact reporting is when we think about the chemicals that are used, we have to think about the media that we are protecting, right? So Rule 208 is a groundwater protection rule. It's making sure that what goes down the hole is accounted for and everyone knows what's down there, and that's the media that's being protected. And that gets to what Director Murphy was saying earlier about why staff thinks it's more appropriate to put the additive prohibitions in the 400 series. There, we're looking a little bit more broadly at things like what could happen if those chemicals that are brought to a site are spilled, right? That's why that additive prohibition table is currently in 411. So the media being protected is surface water and potentially soil. Of course, in the 900 series, we can think about sort of emission standards and ENP waste that deal more with those spills, and also what if some of those chemicals volatilize after they're brought back to the surface. But I want to just clarify that what Rule 208 is doing is really tracking what goes down the hole in terms of that groundwater medium.
Thank you. You answered the follow-up question I was planning on asking, so appreciate that. Commissioner McGowan, the floor is still yours. I stole it temporarily, but I give it back.
I was wondering if staff could maybe also address the purpose of the transfer documents and maybe be a little more clear. There was some feedback in the pre-hearing statements about the transfer not just ensuring financial surety, but the ability of whoever it's being transferred to being able to take care of it from an environmental and health protection perspective. And with the transfer documents and help assure that we know that the operator who's taking over the new whatever it is capable from a financial but also a protective perspective.
Mr. Chair, if I can start that answer, and then I might turn it over to Director Murphy to provide additional gloss on the purpose of the rule, or Ms. Stanczyk to provide additional gloss on kind of the information being received. You know, I think what's important to note is some of what Ms. Stanczyk said at the beginning of her presentation, which is what the purpose of the Form 9 is. You know, the Commission is not the SEC. We don't get to tell operators whether they can complete a financial transaction to buy or sell a company. What we can do is make sure that our records are up to date and that whoever is responsible for a certain part is listed in our database. So I think in some ways we couldn't like block a transfer if we didn't think the operator who was perhaps buying had a very good environmental compliance record. You know, certainly what Rule 218 does is ensures that staff has the information about who's responsible for environmental compliance that allows staff to then use other series of rules, whether it's the 900 series or the 600 series or the 400 series, to make sure that that operator is keeping up with their requirements. I think financial assurance being one of the things that staff checks for is not necessarily a reflection on financial ability to maintain a bond being more important than environmental protection, but rather that's sort of in the category of things that we have to have right in our system, you know, who's paying the bond if something does go wrong. And so that's almost, it's not necessarily a purely substantive thing. It really is sort of a getting it right in our system. So I don't know if Director Murphy or Ms. Stanczyk want to add more to that, or maybe you could even bring in Mr. Dronlow to talk a little more about sort of what the interplay between 218 and the 900 series.
I have one comment. So we haven't talked really in this rulemaking about the financial assurance rules, the 700 series, but currently we have a rule 702 that allows the director to petition the commission to require an operator to increase their financial assurance above the specified amounts in the rules. And when that petition can happen is if the director believes that for some reason, I think it just has reason to believe, that the commission may end up being burdened with liability due to a particular operator, maybe being a bad actor would fall into that. And so in the review of currently a Form 10 and in the future, if adopted, the Form 9, that is part of the consideration that staff would look at and look at who the operator is, what they're acquiring, and that conversation can certainly happen.
Thank you, Ms. Stanczyk. Commissioner McGowan.
Sorry, one last question. So also in the pre-hearing statement, there was a question about determining when it's time to plug or abandon a well and whether or not a local government could request the commission to consider looking at a specific location. And I was just looking for some insight from staff about that.
If I may, Mr. Chair, I'll go ahead and
Go
answer
ahead.
that one again. So that is something that is built into Rule 211, and I think is maybe not completely apparent from the text, but it is very much part of the intent that's discussed in the Statement of Basis and Purpose. And the keywords to look there at in Rule 211 is following a hearing pursuant to Rule 503. And so that does mean that any person who meets the affected person standard, such as a relevant local government or a mineral owner, could request a hearing under the Commission's 500 series rules. And I don't want to guarantee that in every case a local government would be the right person to make that request. Perhaps the mineral owner could, perhaps even it's possible, say a new like a home builder who's wants to build a development and realizes that there's sort of an outstanding well that's no longer used or useful, might be an affected person to file a petition. But I think very likely the local government would probably meet the definition of affected person in that case to request a commission hearing to address plugging and abandoning a well under 211A.
Thank you. Sorry, I am reading everything. It's just sometimes the absorption is not there. Thank you.
Not a problem. Great questions that I'm sure the rest of us would have asked if you didn't beat us to it. Other questions from commissioners? All right, I'm not seeing other questions from commissioners for the staff panel. Appreciate staff being available during the 200 series deliberations and testimony that we're about to get into. And we may have other questions and we'll bring them back on board if we do. But thank you, Director Murphy, for your team's presentation. They have been phenomenal, as have been the drafts that we have received and that Colorado is debating. So really appreciate the work here. And with that, Ms. Larson, where are we at?
Very good question. So where we're at is our agenda provides that we can now move on to party presentations. And we've had a few updates to our afternoon. Two of our parties, Climate Reality and the Colorado Association of Home Builders, have informed me that they will not be presenting. Climate Reality is not presenting at all in the 200 series, and the Colorado Association of Home Builders has requested that they be allowed to use their time for purposes of a closing argument only. So they will not be making a presentation on the 200 itself, just reserve their time for closing. So Mr. Chair, if you and the rest of the commission are so inclined, we could move on to Citizens for a Healthy Community, and then TEP Rocky Mountain would be up next.
And then do we have, after that, we roll into industry and then just all these other parties that are lined out. Is that still accurate?
Yeah, certainly that is what we could do. I am now talking with the parties to see if they would be available to go this afternoon.
Because the rest were supposed to go on Thursday.
That is
right?
So since we're running ahead, I just wanted to double check with folks to ensure that they would be ready to go this afternoon. So we can start with Citizens for a Healthy Community and then move on to TEP. And then hopefully by then I will have heard back from some of our other parties and we'll have a better sense of what our afternoon looks like.
And that's fine. And I also, as one commissioner, would be fine wrapping up after TEP. We've got a lot to think about. There's a lot of homework that we're doing each night. Getting done a little early is not problematic for me. So why don't we roll into Citizens for a Healthy Community and then TEP and then sort of gut check where we are.
That sounds great. Give us a moment and we will start moving in Citizens for a Healthy Community.
Okay, are Citizens for a Healthy Community ready to go?
I believe we are. I see Chris Michalski here And so we're ready to go if you're ready for us.
The floor is yours.
Wonderful. Good afternoon, commissioners. I'm Natasha Leger, Executive Director for Citizens for a Healthy Community. And I've been thinking about the best way to use my 2 minutes with you today since you have read our pre-hearing statement. At first, we were disappointed to see that the 200 series was at the end of this rulemaking since it sets the tone for the rules. But after listening to the battle of experts and the battle of attorneys over the last 2.5 weeks, I think I now see the value in putting it at the end. So I'd like to focus on the importance of words and what they signal. Fundamentally, the purpose of these rules is to ensure the long-term safety, health, livability, and environmental resiliency of Colorado citizens and communities, and that oil and gas operators absorb the total cost of their operations and do not externalize those costs or adverse impacts to the public. Words matter. These words need to be in the 200 series. The 200 series lacks a generalized, easily referenced section that clearly states where oil and gas development is inappropriate. Oil and gas operations proposed under certain conditions are presumed to adversely impact public health, safety, welfare, the environment, and wildlife, and are subject to denial. Words matter. These words need to be in the 200 series. CHC has recommended 16 conditions under which oil and gas extraction is presumed inappropriate and should be stated upfront in the 200 series. A roadmap to issues that are important to citizens is critical to leveling the playing field between industry and the public. A roadmap that aligns with public concerns around, for example, public notice, air quality, water quality, denial, permits, and shutdown orders sends a signal that the rules are about protecting the public. Words matter. A roadmap is needed in the 200 series. CHC has proposed an 11-point roadmap. Protecting the public requires closing loopholes and transparency in decision-making. We appreciate staff reconciling the language in the Statement of Basis and Purpose in 201B. However, ensuring that operators are responsible for the actions of their contractors and subcontractors is not the same as requiring them to comply with the rules. Words matter. Rule 201C must state that contractors and subcontractors comply with the rules. Thank you, and we're happy to take any questions.
Thank you for that presentation. Commissioners, do you have questions for the panel? I'm not seeing any questions, so thank you. And thank you for your pre-filed written testimony and your commentary on the 200 series. With this, we will move to Tep Rocky Mountain LLC as our next panel. Good afternoon, Mr. Jewell.
Good afternoon, and thank you for giving me my rightful last place again. Thank you very much.
How that always works out.
Well, thank you again for your time, commissioners and staff. Michael Jewell on behalf of Terra Energy Partners and its wholly owned subsidiary, Tep Rocky Mountain LLC. Today, just 2 quick points. Number one, that the protection of confidential information is a must, and thank you in advance to Ms. Murphy for explaining some changes there, but we have a little more we would like to ask for in that regard. And number two, building again on our MOU and federal balancing request. So number one, confidentiality and trade secrets are important, not just for oil and gas, but all industries, as Ms. Murphy had indicated. Everyone wants this drive for progress, this drive to have something that is protected so that we can have the incentives to be better and do better. Just like you were discussing in your setbacks, and Commissioner Mesner was talking about bringing something new to the table. And every time we have the opportunity to have a rule, then the juices and mental creativities kick in. But we need that protection. We need more guidance in Rule 208B. We appreciate the nod to due process in 209B, but the procedural right to appeal the director's decision to test or survey does not include the ability to appeal the director's determination of something that is not confidential. So we urge you to take a look at this in draft rule 223 and see what we can add to that. Lastly, AAG Minor discussed the goal of close coordination with local government and federal agencies, and you heard myself and others say something similar. So again, I bring up that overall, the 200 series rules we think should identify this federal intercourse that we have with the rules and the procedures that my client and others have to follow that have a lot of overlap. And we think that everyone is well suited to have an efficiency of agency time and of staff respect if we know what those are in advance and plan for them accordingly. The best way we could do that is by having this task force by the end of Q1 2021 with the director of the COGCC, BLM staff, TERA, other interested parties and other interested stakeholders get together and pound out further on the currently used MOU. To that effect, we know where the baseline is for governance when we're dealing with federal lands. So to conclude, please provide more clarity as far as confidential information. And number two, I think for the third time now, let's look at this MOU task force idea so we can make sure efficiencies are the best they can be. Thanks for your time.
Thank you, Mr. Jewell. Are there questions for Mr. Jewell? All right, we appreciate your testimony, Mr. Jewell. Thank you for that. And we will turn it back to commission. Commissioners, we are now through with the agenda for the day. Do folks have thoughts about next steps? And I guess what that really means is, do you want to call it a day and then come back tomorrow and be on schedule as well?
And if I may, Mr. Chair, I might be able to help in that decision.
I'll turn it to you next. Thank you, Ms. Larson.
So far, the folks I've reached out to, that most of their witnesses are not available, so it doesn't look as if we're going to be able to proceed with anyone else this afternoon.
Okay, very good. Ms. Larson, during the break, I floated a proposal to you about scheduling, and I think I also floated it to Ms. Murphy. Again, in discussions that I've had with staff, we have, as we mentioned, we're being nimble with the 8, 9, and 12, and it gives staff more time. Staff is working hard on finishing up the feedback back to us on rules. And currently, as scheduled, we were to take up 200 testimony tomorrow, I believe, and then go into deliberation in 200 tomorrow afternoon. And then currently, we were set for additional deliberation on Friday on 200, and then staff presentation on 2 to 6. Our Children's Trust rulemaking petitions, and then party statements regarding staff's 200 to 600. What my proposal is suppose we, and this is a little bit contingent on us getting through 200 series deliberations tomorrow afternoon. I don't think we have a ton of as much party input into 200, and so we might be able to get that done. And if we do, I would suggest we think about hearing from the Our Children's Trust on Friday, but maybe stopping at that point, and that gives staff some more time to get the 2, 3, 4, 5 back to us, perhaps by close of business on Friday, and that gives all of us and all of our stakeholders a chance to read through all of that, think about it over the weekend, and then we could hear closing statements from staff and or from parties. Everybody's got 3 minutes, I think, to start Monday, and then we could go into kind of the final deliberations fresh next week after having heard the closing statements. That's totally optional on our part. I'm trying to build a little more time for staff. And I'm also recognizing that we are in an endurance event and this is not a sprint. So before commissioners weigh in on that, Director Murphy, Hearings Officer Larson, AAG Minor, do you want to weigh in? Would that adjustment be helpful? Is it not necessary? What are your thoughts?
Fair. I would start by saying a little bit more time will leave staff slightly more cogent when we're presenting feedback back to you based on what we've heard over the course of the last 2.5 weeks. I think that we could be in a place to turn drafts around Friday afternoon for everything except for I mean, I want to put a little asterisk on 200 because I don't want to foreclose what changes may or may not come from the conversation tomorrow. But it would certainly give folks a little bit of time to work through those changes in advance of providing comments to you Monday. I think staff could also be in a place to kind of button up a pretty tidy presentation Monday morning in terms of what we heard and why we did what we did in those changes. They're fairly focused, but they will initiate some kind of broader intersection conversations, especially as it relates to ALAs and setbacks. So from my perspective, I think it would provide for a better experience for everybody. At the same time, if the idea is to help folks get through it now so they have more time to digest, we're here for you.
Thoughts, commissioners? All right, I think we have 3 thumbs up and probably 4. I maybe missed one. Yep, okay. I think we're all going to go this altered route. So Ms. Larson, and I apologize, but I'm always making you change the calendar. But if you could change the agenda to reflect this and get that out to our parties and on our website this evening. And then we will make this edit. We'll continue to be nimble. At this point, I think that we are looking for a motion to adjourn until Thursday, September 10th at 9 a.m., at which time we will come back and listen to the party presentations that are calendared for that day. At day 13, we are still somewhat on time.
So moved.
And a second?
Second.
All right, all those in favor signify by saying aye.
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 Any opposed? We are adjourned. Thank you, Colorado. Thank you, stakeholders, for being with us. And we will see you in the morning.